Greetings to everyone. We hope you all are doing well. I, K. Suman Gowda, welcome you all on the behalf of team of Legality Viability to this interview of Ms Ana Sambold. Welcome, ma'am. At Legality Viability, we aim at providing excellent services to our partners and ambitious students in order to help them achieve their goals. We launched our services on 1st of April 2020, and since then, we have been partnering with campuses all over India and growing day by day. We provide services like free legal lectures as well as notes pertaining to concepts of law, which help the students with their studies. Now, to speak about our guest for this interview, Ms Ana Sambold. She is an international leading figure in the field of dispute resolution. She is an attorney, mediator, arbitrator, conflict resolution specialist, and the focus of her practice is helping individuals and companies to resolve their disputes in an expeditious and effective manner through alternate dispute resolution medium. She's an International Mediation Institute certified mediator and also a member of the Chartered Institute of Arbitration. We are sure that this interview will direct a lot of aspirants in an effective direction. With no further delay, I seek your permission to commence this interview, ma'am.
Hello, everyone. I'm delighted to be here today.
May we proceed with the questions, ma'am?
Okay.
So, ma'am, as my first question, I would love to know how, from your perspective, ADR or alternate dispute resolution happens to differ from conventional litigation.
Okay. Hi. Good morning, everyone. Oh, good evening. And here in San Diego, California, where it's 10 a.m. I'm delighted to be here today to talk to you about ADR, mediation and arbitration. And to answer Suman's question, well, there are different ways to resolve disputes. And the traditional way is litigation, taking your case to court and having the judge deciding your case. But there's a new, there's a field of the alternative dispute resolution that is basically mediation and arbitration, and it's called ADR because there are alternatives of dispute resolution to comparing them with litigation. So through mediation and arbitration, you can resolve disputes in a different way. And unlike taking your case to the judge, you will take your case to a mediator or an arbitrator. And the difference between the two of them there are a lot of difference between the two of them. In mediation, we have a neutral person, the mediator, helping the parties resolve their case by facilitating a meaningful conversation between the two of them. The mediator doesn't determine who is right or who is wrong, or has any power to force the parties to do something, at least here in California, the way that we practice mediation. I understand in other countries, in other jurisdictions, they have different ways to mediate, but that's how we mediate here in California. So the mediator just facilitate the resolution of the dispute and basically acts as the third party that help them negotiate a claim or dispute, and at the end help them to reach an agreement. But in arbitration, that is the second form of ADR, in arbitration, you take the case to an arbitrator, and the arbitrator is the deciding your case. So unlike a mediator, the arbitrator has the authority or the power to decide who was right and who was wrong, and decide in favor or against one of the parties. And the parties will have to present their case in a hearing, just like like going to court. The arbitrator will decide based on the presentation, based on the hearing, based on the evidence presented to him, will decide and and his decision is called the arbitral award. And normally here, at least in the States, the arbitral award cannot be appealed, and except for a few exceptions. And, but in general, they're totally different systems. But they're called alternative dispute resolution because they're ways to resolve conflict out of court. That's the main difference between the two, between litigation and ADR.
Yes, ma'am. Also, ma'am, do you think the object behind the coming up of ADR was to provide an expeditious justice? That was on a regular basis. The conventional litigation always occupied a very large segment of time. For instance, cases used to go on for a very long period of time, and in order to like get away from this aspect, I believe ADR was introduced. Do you think in the current period ADR is serving the purpose that it was introduced for?
Oh, yes. And especially now with the pandemic, well, at least here in California, the courts were closed in the beginning of the pandemic, from March to May. And right now, finally, the courts are catching up or trying to catch up with all the cases and all the backlog that they have. And so at that point, people couldn't, trials weren't conducted, and the people didn't have an option, didn't have a way to resolve their disputes. So mediation or arbitration, especially online mediation and arbitration, it become a really effective way to resolve conflict and those disputes that they were stuck in court. And so right now, people can take the case to an online mediator or an online arbitrator and can have resolution and fast and effective resolution of their case, and in a way that is pretty convenient because it will be conducted online. If they take it to a mediator, it's pretty informal and it's pretty flexible and pretty effective, and and it's a lot of it's a really fast way to conduct and resolve a case. You just conduct a mediation or arbitration. Mediation, I normally have cases, and in 13 or 14 hours maximum, we get it all resolved online. Oh, an arbitration depends of how complicated the case is. It can be conducted, the hearing can be conducted in 1 or 2 days, and have the arbitrator deciding within 14 or to 30 days, compared to take the case to you take the case to litigation. Who knows when you can get a trial date now. Hearings are really, here in the States, we have the jury system, and it's
Yeah.
impossible now to get people to attend and to gather at the courthouse to serve as the juror for a case. So that really complicates everything. So mediation and arbitration are, are really an effective and time fast, and they're fast and efficient ways to resolve conflicts nowadays.
That's very true, ma'am. Now, leading to second question, could you share your perspective and insights into the process of how to go about with different forms of active dispute resolution?
So, well, as I mentioned, the two main ways, are mediation and arbitration of ADR, and they're different. And in mediation, you want to take your case to mediation, and I get many of my cases in mediation or arbitration, because the parties, when they have a contract between the two of them, they provide for a clause or a provision that stipulates that in case that they have any dispute, the parties agreeing to take the case first to mediation and second to arbitration, or only to arbitration or only to mediation. So that is one of the main ways to get to mediation or arbitration, because the parties have provided for in the contract. And I think so this is one of the most effective ways to provide for ADR. And in that way, you can prevent in the future that your case or your dispute with the person that you're contracting with, that you ended up in court and you ended up involved in this long and expensive litigation. If you provide for that, for mediation or arbitration in your contract, that would be a great way to prevent the future and future costs and future stressful and extensive litigation. Um, but the difference, I would say that if it's not provided in the contract, the parties are always free to decide if they want to take the case to mediation and or arbitration, and they're free to select the mediator or the arbitrator they want and take the case to them. There are many, at least here in California, the ADR field is huge. And there are many mediators and arbitrators and many companies or panels that provide those services. So when the litigators know that part of the system um, is taking your case to a mediation or arbitration, part of the process of litigation. In fact, they say that 98% of the cases or the disputes that they file in court are resolved by mediation or arbitration and not by trial. I always joke that alternative dispute resolution is not really alternative. The alternative is litigation, because if 98% of the cases that are filed in court are being resolved mainly in mediation and arbitration, well, the alternative is litigation. But those are the cases that basically people, the parties, they tried to mediate and it didn't work out, or they didn't want to take it to arbitration, so they decide, okay, this is it, we had to take it to court and we had to take our chances and taking it to the judge or the jury to decide. But those are few exceptions.
Yes, ma'am. Ma'am, following up on whatever you just said, can we agree on the fact that an option as to select whether to go for an arbitration or a mediation depends on the stakes involved in the particular case? For instance, when the stakes are very high and the
Yeah.
parties feel that they can't mutually agree upon a term, and I personally feel that that's the time where you can actually opt towards arbitration, where a person actually hears you out and decides upon, and then awards the stakes towards whomever it belongs to. Whereas when the stakes are a bit of considerably mid-range, then the parties can opt towards mediation, where they can mutually understand, mutually come to an agreement. This is my perspective. I just wanted to know about yours.
Yeah, and that's what I always and always glad when parties introduce a provision in their contract, like preventing or predicting that if something happened down the road, they have to, is mandatory by the contract, and it's not an optional, because I know when the parties are already in a dispute, it's so hard to get them to agree to select the way that they're going to resolve their dispute, because obviously the people is very contentious and emotions are high, and at that point they don't like each other that much, and so they don't want to deal with each other, so it's really hard to get them to agree to the system or the way that they want to resolve their dispute, right? And sometimes I have cases when the provision provides for mediation or for arbitration or for arbitration only. And the parties have a hard time selecting the mediator and an arbitrator. So that's why I would say, please include in any contract and anything that you provide any services, or you provide any, or you getting into any transaction with somebody else, always provide for an ADR clause. Here in California, for example, in any transaction, any real estate transaction, when you buy a house or when you sell a house, for example, every time that you have to get into a real estate transaction, the provision had to be included, and they is mandatory. The people have to select. You have to take your case first to mediation or second to arbitration, but at least one of the two. That always had to be in the contract, and that prevents a lot of litigation.
Ma'am, would you let us know about how you actually became a mediator and an arbitrator?
Yeah, of course. Well, I in California they have different requirements, and I guess in India they have another ones. But in general, to become a mediator, they are basically no requirements. So anyone can be a mediator. And so we have many people from different backgrounds, like real estate agents, professors, psychologists, becoming mediators. And they concentrate on a specific type of disputes, like real estate disputes, or like um, divorce disputes, and they become mediators of the field where they have a good background in it. But in commercial, say, and in litigated cases, it's always very hard to get selected as a mediator case if you don't have a license, or you didn't practice as a lawyer before. And they because there are so many mediators and there's no many requirements, so the ideal is to have that a retired judge is to decide and help the parties in dispute, either through a mediation or arbitration. And but in regard to with, so you have a dispute about security stocks, you want somebody that has background and knowledge in that, so you can appoint an arbitrator that has that background. So but they in general, I think so you is always beneficial if you want to be a mediator or arbitrator of litigated cases, to be a lawyer and to have a previous extensive experience in law, practicing law. And then just go and attend different trainings in mediation and arbitration. I think so. I have taken pretty much every single mediation and arbitration training available in the world. I have been trained at Harvard Law School. I have been trained in Pepperdine Law School here in California. I have been trained by the Columbia Law School, the Charter Institute of Arbitrators, you name it. Every single training, there's so many out there, but those are probably the ones that the biggest ones, or the most renowned ones, in the East Coast, Harvard mediation program, and in the West Coast here in the States, the Pepperdine program. So I went through all those trainings, but I always believe that you should never stop learning. I always and continuously look forward to learn more and improve my skills and learn and master and hone my skills. In that way, I can offer and I can be a better mediator and arbitrator.
Uh, I believe in in a similar perspective that the world knows a bit more than whatever we actually know. So it's always better to learn out there rather than trying to tell people that we know. It's always better to learn. So following this, ma'am, could you give us a few tips, as we could term it as, when it comes to career, as to how to approach law school and achieve goals?
Well,
For instance,
what I
yes,
would
ma'am.
recommend to law students, I would recommend if you want to become a mediator or arbitrator someday, so just get in as many educational programs and learn about it, build your resume, and start. you have to, in some way, to get credibility in the future, you have to practice law, and you have to know about the litigation and practicing first before you become a mediator and arbitrator. Because I can imagine, and probably in India the same thing. There's so many people, and it's very competitive. So you had to stand out from the crowd, and so the way to do it is just learn, get trained, and practice for a while, and then jump into the mediation and arbitration world, and join a panel, and try to build your reputation as somebody that knows about it. And just but uh, mediation and arbitration are not those type of professions that you can do after graduating from law school. You have to, and the what I see is that that is almost as a second profession in life. So you had to be patient, and that's what I would recommend law students, to be patient, because it's nothing is not going to happen overnight, that you're going to graduate, you're going to say, oh, I took this training, now I can call myself a mediator, now I'm going to get tons of cases. Well, at least here in the States, that doesn't happen. You had to build your resume, you had to spend many years training, practicing, and then you will have a chance to be selected for cases. Because at least here, that's the way it is. There's so many choices and so many options and so many amazing professionals that are available, like I was mentioning, retired judges. So is you have to basically, the litigators are obviously comparing you with with experience and retired judges. So you have to build your resume
So in
in
general,
a way that makes it appealing. Yes.
it's a very competitive world, you mean to say, when it comes to even mediation as well as arbitration. Because
Yep.
when we can place a student who has just graduated, who thinks that uh, passing out of a course on mediation or arbitration will make him an arbitrator, and when he realizes that he has been put on a similar footing as that of a retired judge, I believe the ground would go off from his floor. Proceeding to our next question, ma'am. You have been a part of very prominent institutions or panels across the globe. So, what, according to you, is the right approach to be part of these institutions as a mediator and an arbitrator?
Well, as I mentioned, you had to be patient. You had to build your resume. You had to build your credibility. So that takes many years. And after many years, finally the panels are inviting you to participate or be part of them. That is mainly by invitation. When they recognize that you are a prominent figure in the field, they invite you to join, and that's how you can get on those panels, at least in the big ones. And but it is a matter of time, a matter of building your practice, is a matter of gaining experience. I have mediated and arbitrated almost 1,000 cases in the last 10 years. And so that's why it belongs to different panels, and I mediate mainly commercial employment, um, um, multi-party, multinational, international disputes. That's kind of my specialty.
Yes, ma'am. So, ma'am, what are your perspectives on career in ADR when it comes to post-pandemic conditions? Uh, After this
I'm sorry,
condition,
Saman, you cutting off.
I'm sorry, ma'am. My question was, what are your perspectives on career in ADR after this pandemic conditions? Would it widen up or become much more narrower?
Well, I would recommend to law students, just hang in there, finish your studies, and try to find internships in a regular law firm. I guess they're offering now online a virtual internships, and
Yes, ma'am.
trying to get as much practice as you can, as a lawyer, as a practicing lawyer. and just learn as much as you can about mediation and arbitration. And thank God nowadays there's so many programs and webinars online about mediation and arbitration. And I'm amazed about how many law students they're now interested in more in ADR all over the world. And so
Very much, ma'am.
I'm so glad about that, because that shows that people wants to, and hopefully law students start bringing more ADR into the field, and at some point it will become the main way to resolve disputes. So because I guess sometimes I feel like the public in general, it still doesn't know that they have those choices. And sometimes I find myself talking to people that are no aware of, no familiar with the concept of mediation and arbitration. Sometimes they say mediation, what, meditation, medication. And I had to explain that there's a different, that is a way to resolve conflict. And I had to explain the difference. I had to explain the how that works. And all the time, by the way, presenting, the next week I had 3 presentations to business associations and to different groups, just to introduce the concept of mediation and arbitration to the public in general. So, and is I'm pretty sure in India it's almost the same. Sometimes people get confused with the concepts and they don't really understand. And so when they're involved in a dispute, they don't know that that's an option. So I think there's a lot that we can do to educate the public. So that's what I'm delighted to hear, that so many law students nowadays are interested in learning more and more about ADR, because that means that more and more people are going to be aware of these options and they're going to start using them more in the future.
I believe India is in very much need of ADR, ma'am, because we have a
Exactly.
fact that says this around 3 crore cases that are pending before the courts. And I believe in case people resort to ADR, then the burden on even the conventional courts would lessen a bit. Moving to a final question
Yeah,
for the day, ma'am.
especially exactly, especially now with the pandemic, is just very sad to see the people, they don't have an option. The courts are backlogged, and many businesses are struggling now to stay afloat, and it's pretty sad. So I think so ADR is representing a really good way to help humanity in general, to um, deal with the situation, deal with the pandemic, and deal with our current problems. Because yeah, we don't need more litigation and more stressful and expensive litigation when we have these options. We have mediation where the parties can resolve their conflict in a collaborative and proactive way, and we can do it online, and provide some type of resolution and closure to their cases.
As you rightfully said that even though ADR is a very much proactive and a very beneficial medium to resolve disputes, but awareness of the same is actually hindering the benefits from reaching the people, I believe, ma'am. I guess an effective awareness has to be created throughout the world, so people act, like everyone out there, whoever has even slightest, who's prone to disputes, has to be aware of the fact that ADR is a concept that exists that can benefit them.
Mm-hmm.
And now moving to a final question, ma'am. Provided that you're given with an opportunity, what big changes would you like to make in the existing field of ADR, ma'am?
Well, uh, changes. I would make the changes is into the mindset of people. That's what I would like to change, because sometimes when people is in conflict or involved in a dispute, they just want to fight and they just want to take the case to court, and they just. But at that point, I'm pretty sure. Um, the majority of, they don't know what are the consequences and the cost of taking the case to litigation and to court. Is a process that is painful, is destructive, is expensive, is takes super a lot of time, and is and so I would love to change that mindset in people, and I would love to see them embracing a more collaborative way to resolve their disputes through mediation, especially through mediation. I'm a big fan of mediation. Sometimes I get cases in arbitration and I just amazed because if they will have the opportunity to mediate that before going to court or before going to the arbitrator, they will be saving so much time and money, and the whole process is just stressful and consuming. And like I said, this is the last thing that we need right now with everything that is going on.
That's very much. Following up with whatever you just said, ma'am, you just said that people's ego is what makes them to actually turn a dispute into a fight where they want to win over each other in litigation rather than trying to come at an agreement through mediation. I believe that's what's actually affecting people from opting for mediation, that very ego and people's mindset.
Mhm.
So this brings us to the end of this interview session, ma'am.
Well, thank you for inviting me today.
The pleasure's all ours, ma'am.
Thank you.
So, ma'am, I would like to proceed with word of thanks. Um, I would like to thank our esteemed guest speaker, Ana Sambold, for her time and such an enlightening discussion which covered several aspects that form an essential base for the law students. I would also like to thank the entire team of Legality Viability for organizing this session, and would again like to thank ma'am for her time to come on board with us and talk to our listeners. Thanks a lot, ma'am.
Thank you.